I hope everyone's doing well. So today's session is about the farm acts, right? The farm laws that have been enacted in 2020, in late 2020. Uh, the idea today is not to cover the farm acts in depth. I'm sure all of you are aware of the broad provisions of those farm acts, right? So I'll be giving a brief introduction of the farm acts, but more importantly, in today's session, what we will be covering is the kind of legal linkages to other legal concepts that we do for CLAT and for ALET and other law entrance exams. So the structure of today's this video is going to be that first of all we'll do a brief introduction of the three legislations that are in question, and then we'll spend slightly more time on different linkages that can be drawn to constitutional law or to contract law or to some other bodies of law. So that's the aim for the day. So as you would know, these are the three relevant legislations, the three farm acts, right? So there's the Farmers Produce Trade and Commerce Act, and there is the Farmers Agreement on Price Assurance and Farm Services Act, and then there is the Essential Commodities Amendment Act. All three together, they came in a package, sort of. They were passed together, they were introduced together, and that package together is, informally known as the Farm Acts, right? So this is a brief overview that the Trade and Commerce Act, right? The Trade and Commerce Act allows farmers to sell their products outside of APMC mandis, right? Now, till now, there were state legislations providing that farms produce can only be sold at APMC mandis. It cannot be sold outside. So different states have their own legislations providing for this. Now, this legislation seeks to override that earlier provision. They say that, uh, not only can sales be made outside of the mandi, sales can also be made on an interstate basis. So someone from Punjab can sell in Haryana, vice versa, right? The second legislation is the Agreement on Price Assurance and Farm Services Act, which is basically about contract farming. That I am, for instance, say I am PepsiCo. I make Lay's. I hire a farmer to make to grow potatoes for me, and then I will process those potatoes and I will make Lay's. Right. The third legislation is the Essential Commodities Act. Now, the Essential Commodities Act is an old legislation which basically provides that that different commodities, such as recently PPEs, right? These commodities are controlled by the government. In the sense, government can order that someone necessarily has to manufacture, distribute, supply these commodities in the manner that the government wants them to, right? So commodities that are nationally important can be made, can be controlled by the government. Now, one aspect of that law was that there was a storage limit. There was a storage limit under which the idea was that no person can store above a certain quantity of a given product. The purpose, as you can imagine, of this exercise was that hoarding is not possible. What is hoarding? Hoarding is the act of keeping something in storage, right? If something is kept in storage, letting its supply in the market go down, right? So the demand remains constant, supply goes down. What happens? The result is that the price shoots up. So now when the price shoots up, you release your goods and you make profit. So that sort of activity was prohibited by imposing a storage limit. Now what has happened? Certain farm products like cereals, pulses, potatoes, onions, etc., right? They have been removed from the list of goods for which storage limit was imposed. Which means what? Which means now there is no storage limit whatsoever for for these farm products, which means that hoarding is now possible. So that's a brief overview of the three legislations, right? So there are some slides that I have prepared for these three legislations. If you want to have a look, feel free to have a look, right? And we've discussed most of it. There are some concepts that we will go through though. First is MSP, minimum support price. What is the legal status of MSP? Now, the legal status of MSP is that it is not a part of a legislation. It is not a part of a legislation. It is a governmental policy. And what is the policy? The policy just says that the government will provide X rupees per kg or per quintal for a certain kind of farm produce. So that even if the price in the market for a certain crop goes down, the farmers have some assurance that, we are going to get X money from the government. So that's MSP, and it is not in law. That MSP is not in a legislation, it is only in a policy, which means it can be retracted at any point in time, right? Then the second legislation is about the Price Assurance and Farm Services Act, which broadly provides for contract farming. Now, what is interesting about this legislation? What is interesting about this legislation is that there is a dispute settlement provision, which says that if there is any dispute with respect to contract farming, that dispute will go to the subdivisional magistrate. Subdivisional magistrate is basically an IAS officer who is posted in a district, right? So that dispute will go to the subdivisional magistrate and then to the appellate authority within the act. Courts are not involved. So in a typical contract matter where there is a dispute, where do you go? You go to a civil court. But here they have said, no, you will not go to a civil court. You will only go to the SDM or the appellate and then the appellate authority. So that's something to remember. So that's an aspect that needs to be remembered. Then there is the Essential Commodities Act, which I have already broadly discussed. That it was an original legislation of an old legislation. It's a 1955 legislation, right? Where there existed storage limits. Now, some crops have been declassified they've been removed from the storage limit provision. So this is broadly, this is what these three farm acts have done. And on the basis of readings that you must have done, newspaper articles that you may have read, editorials, etc., that you may have read, right? You already know all of this. I've just given a broad introduction for the sake of this video so that we can discuss some legal issues that arise from them. So let's look at what are those legal issues, right? So we're not discussing specific provisions of these legislations. That's not what we're discussing. We're discussing how are they linked with other legal concepts that we study. So I think there are three areas of law. There are three areas of law where possible linkages can be drawn. There are three areas of law. First is constitutional law, right? As you would know, if there is any legislation, that legislation has to be constitutionally proper, right? So the first part of constitutional propriety is that it should be made by an entity that is permitted to make it. So as you would know, there is a division of powers among the parliament and the state legislature, that there are certain topics on which the parliament can make laws, then there are certain topics on which the state can make laws, and there are certain topics on which both of them can make laws, right? And where are these topics provided? They are provided in Schedule 7, and there are three lists. There is the union list for which the parliament can make law, then there is the state list for which the state legislatures can make law, and then there is the concurrent list for which both of them can make laws. Now, what's the status here? Now, as you would imagine, these laws pertain to agriculture. Agriculture is provided in which list? Agriculture is provided only in the state list. So there is an argument to be made that Parliament did not even have the power to make this law. Now, in response, people may come up and make an argument that, hey, for Parliament has what is called residuary power, that if there are topics that are not mentioned, then Parliament can make law on it. In my belief, and of course, this is nothing about this is final. It will gain finality only when it is decided by the Supreme Court or some High Court, right? In my estimation, I don't think this is a strong argument, because this is squarely covered by an entry in list 2, which is the state list. This is squarely covered by that. So This is one aspect that, there is a federal structure that we follow. There is something that parliament can make laws on. There is something that state can make laws on. And this farm acts, these pertain only to what is covered by states, right? What is covered by the list 2, which is the state list. The next argument can be in relation to equality. The next argument can be in relation to equality. What's the equality argument here? The equality argument can possibly go as follows. The proposal in this law, now not just proposal, now it's a law. The law says that some money will be charged if trade in these commodities happens in APMC mandis, but no tax will be charged if the trade in this very same commodities happens outside of trade mandis. So if the conception is that the nature of money taken in the mandis is of tax, if that nature is a tax and no tax is being taken outside of a mandi, then they are basically treating two equivalent things differently. And that's what equality is about, right? That if there are two equal things, you cannot treat them differently. You have to give them equal treatment, right? Now, someone may make an argument in response ki, in mandis, the price that is being charged, the money that is being charged is not a tax, it's a fee. That, mandis provide you some services. Mandis provide you storage, they provide you handling, they provide you auctioning, right? All these services are provided by the mandi, which needs infrastructure, and that infrastructure needs maintaining, and therefore they deserve to have this fee. And I think if that argument is made, I think that argument would be a valid argument. So I think there is some equality argument to be made, but it may not be a supremely strong argument. Then we come to the right to life. Now the Supreme Court has held that in the right to life, there also exists the right to access food grains at an affordable price. Right? So Supreme Court has given guidelines to the government and the Food Corporation of India in the past that you have to ensure that enough storage of food grains remains, right? Why? So that everyone in the country, especially those who can ordinarily not afford food, they have access to food. Now, because of this limitation on the storage limitations being removed, right? Because of those storage limitations being removed, there is a possible implication that the availability of food grains in the market may go low because people will hoard. Right? And I've described what hoarding is. Right? So there is a potential implication on right to life. Is this a very strong argument? No, I don't really think so. But that argument exists. Now let's look at contract law. One contract law issue is of undue influence. Why does an undue influence issue exist? Because so what is being allowed here is that private players are now allowed to enter into this market of trade of food grains, right? Now, a big corporate honko, right? A big corporate entity is entering into this market and will want to enter into a contract with a marginal farmer, a small farmer. There is a vast difference in bargaining power. There is a vast difference. Because there is a vast difference, there is a risk that this entity is in a position to dominate the will of the marginal farmer, and they can use that dominant position to cause consent of this marginal farmer. And that is the definition of undue influence. Am I making a claim that undue influence will exist in every single contract between a corporate entity and a marginal farmer? No, that's not the argument that I'm making, right? But the argument that I am making is that because of the power difference, the chances that undue influence may exist, those chances increase, right? Now, Another important issue from a contract law perspective comes from the second act, the second law, right? The Price Assurance and Farm Services Law, which says that contract farming is permitted. That contract farming is permitted. And what can be the period of contract farming? The period of contract farming has to be minimum one crop season and maximum 5 years. You can go beyond 5 years, but to go beyond 5 years, you have to explicitly mention in the contract. So, so you can go from one crop season to 5 crop seasons. Now a problem exists where what if in that crop season or in any of those in the term of the contract in that time, a problem is what if there is no monsoon or less monsoon or earthquake or fire or some other natural calamity? That is basically an impossible event, which will make that's a natural event that will make the performance of this contract impossible. Therefore, the contract will stand frustrated. So there will be problems with respect to this. Now how will farmers and these corporate entities or whoever is buying from farmers, need not be corporate entities, can be non-corporate entities as well. How will they deal with it? They will deal with it through what are called force majeure clauses. So for those of our viewers who have attempted Clat 2020, you would remember the first passage in Clat 2020 which pertained to force majeure. Now, force majeure clauses basically permit you to do what? To customize the situations in which the performance of a contract can be suspended, or the deadlines can be delayed, or the quality requirements can be reduced, right? So it allows you certain customization possibilities. So it remains to be seen once contract farming starts in full fervor, right? It remains to be seen what kind of force majeure clauses are drawn up. It remains to be seen, and it will be interesting to see if there are confidentiality agreements. You know that the farmers are not even permitted to disclose what kind of agreements they've entered into with corporate entities. And if they're not, then it is possible. If they're not allowed to disclose them, then it's possible that something fishy is going on, right? So there's a force majeure element to this contract as well, and it remains to be seen how this will be implemented in this industry going forwards, right? Before I head to competition law, there's another issue that just struck me from a constitutional law perspective. That issue relates to the limitation in the Price Assurance Act, the limitation that any settlement of dispute necessarily has to happen in front of an SDM, a subdivisional magistrate. Now, there are two potential problems that I see here. One is a right to equality problem that, farmers will make an argument ki what is so special about our case that it can't go to a civil court? Why are ordinary contracts allowed to go to a civil court but not this one? Why is a judicial mind not permitted to apply its logic here? Why is a non-judicial mind? And of course, an SDM is not a judicial mind. A judicial mind is a judge, a civil judge in this case, right? Why is a judicial mind not allowed to apply its logic here? We don't know yet. We don't know. So that is one equality argument that can be raised. The other argument is, and it's not really an argument, it's an implication. That implication is that once an SDM decides and then an appellate authority decides, if one of the parties is not happy with the decision of the SDM, then it goes to the appellate authority. Then what happens? Is the decision of the appellate authority final? No, it's not. Why? Because the aggrieved party, whoever is not happy with the final decision, that aggrieved party can approach the High Court under Article 226, which is the writ jurisdiction of a High Court. But the amount of judicial review that a High Court can do under its writ jurisdiction, that amount of review is smaller. So a legitimate question exists. Why is it that a civil judge is not permitted to decide what is clearly a matter of contract law? So that question has to be answered. The next aspect that I would like to draw a linkage to, and you may not really be aware about, is to competition law, right? So let me lay down some groundwork for this, right? Let me lay down some groundwork. So what is the fear of the farmers here? The fear of the farmers is key these private players will enter the market. They will keep the prices low for some time. If they keep the prices low, then what will happen? The mandis will go out of business. Then the mandis are out of business. Now only these private players remain. Since there are only few private players, now they will make things difficult for the farmers. They will make things difficult for the farmers. That, and to put it another way, they will make lucrative deals to begin with in order to oust competition. And then those deals would end. I mean, if you want to take an example, take Uber. When Uber started, do you remember the sorts of offers that Uber was giving out? What did that result in? That resulted in your ordinary taxi stands. They all, a lot of them suffered huge losses, and some of them even went out of business. That's the argument that farmers are making. That when a private player enters this market, they will give lucrative deals to begin with, and then capture the market. Right? That's the groundwork. Now, how can this be? How can this be targeted? How can this be solved? One possible One possible way to solve this is competition law. There exists competition law, or it's called antitrust law, competition law. They're the same thing. There is a Competition Act 2002, which basically is made to ensure that there is balance in the market, that there is no entity or no set of entities which is completely dominating the market, right? So if an entity reaches a dominant position in the market, there are certain restrictions imposed on that entity. That entity cannot do any sort of pricing that it wants, right? Then, if say only two or three private players enter into the market and they come into an agreement ki bhai, we will treat the farmers in X way, and that X way is detrimental to the farmers, then it is said that they have formed a cartel, right? And cartelization is not permitted. So, and all of that is provided in competition law. So there is some potential interface to be drawn with competition law, and perhaps it needs to be explored on it needs to be explored how competition law can assuage some fears of the farmers that they've been raising for the past few months, right? So that's it from us with respect to farm laws. If there's anything that you want us to focus on, please feel free to write to us at help@clatpossible.com, and we'll be happy to assist you. Have a good day ahead, and thank you.